Hi, everyone. Thanks for joining us. I'm Coley Bartow, the coordinator for continuing education at the State Library. We have our webinars and other continuing education opportunities funded by the Institute of Museum and Library Services. We want to acknowledge that support for our activities. Everyone is muted. We encourage you to use the chat to ask questions and discuss with other attendees. As you exit the webinar, as always, I will share that ubiquitous link to our evaluation form, and we appreciate your feedback on that form. We are joined again with our friend Kris Goss, who is the Director of Library Learning Hub at Helena College of the University of Montana. And we have a lot of information to share in this session. And so I just want to give Kris as much time as he possibly can have in this really interesting topic. This is something that jumped out at me as something I didn't know a whole lot about. And as someone who has become more aware, I guess, of the amount of cameras and, obviously we all almost all have a phone in our pocket that can take video. But thinking about what that means in public spaces is really intriguing to me. So with that, Kris, I am going to stop sharing and please feel free to take over.
Thank you, and thanks everyone for joining us today. This is a topic that is a lot of information, a lot of different strands that go in different directions. And so we're going to talk about a couple of different aspects of it. First, the general surveillance that Colleen mentioned when you look up and you see cameras watching you, and how those cameras and those technology and that platform relates to library operations, but then also some of the emerging technology that's related to more traditional surveillance and how that can relate to library operations, but also that individuals, non-library staff or volunteers working on personal projects or curiosity filming in public spaces and how that can be governed by different laws and library policies. So a lot of different topics related to surveillance, recording, and then the responsibilities of libraries regarding confidentiality and how it kind of all fits together under Montana law. And that's our goal, is to make sure that you have, again, that foundation of knowledge, building on the last several weeks that we've been looking at different policies, ways to develop policies, ways to ensure the policies comply with state and federal law, comply with local ordinances, so you are able to have the confidence to handle these situations, monitor them appropriately, and develop workable procedures and protocols to help your library deliver services to your patrons. And so that's our goal. That's what we're going to be working on. And so we start with the question is, what Montana laws address surveillance and recording in libraries? And so let's move through the constitutional provisions, which is, if you've been watching the last few weeks, we like to start at the beginning, and in the beginning in Montana is the Montana Constitution, and those specific provisions related to the rights of citizens and the rights of each Montanan. We have a very profound statement in Article 2, Section 10, that the right of individual privacy is essential to the well-being of a free society and shall not be infringed without showing a compelling state interest. That's a sentence that many states are probably envious of, that it exists in our state constitution. It's one that every Montanan knows that they inherently have as a human being, but as a Montanan, it's documented in their constitution that I have a right of privacy, I have a right to be left alone, I have a right to engage as to how I feel is necessary with the government and with others. And the government should leave me alone unless there is a legitimate, compelling government interest to interfere with my right of privacy. And so we'll talk about that provision of a compelling state interest and how it relates to the operations of libraries. But there's an extension of that right of privacy. It's not just people who are adults. It extends to persons under the age of 18 as well. because people under the age of 18 have the rights outlined in our state constitution, unless there is a specific aspect of state government operations or local government operations which require some different application of those rights. So each individual has a right of privacy, and each person, regardless of age, holds that right of privacy under our state's constitution. We know that. We know we have that right to be left remotely secure in our confidential private papers, thoughts, knowledge, and how that extends to a library is going to be handled by a series of different state statutes. We think back to the Constitution providing the foundation for our state government framework and legal framework. Then the statutes are the interpretation of that Constitution and the application of it as developed by the legislature and signed into law by the governor and reviewed by the state court system. These statutes are based in the state's criminal code. If you remember last week, we talked a lot about the criminal code regarding disruption of the public order, disruption of public meetings. And this is a different aspect of the criminal code. These are the rights, the expectations of citizens to not have their right of privacy interfered with through recording or surveillance that they're not aware of. And so 45-5223 says it's illegal for someone to take footage or recordings of another person in their residence or in a public way that violates their individual right of privacy. And it gets into details about someone being secretly recorded in a public space when their personal effects or their personal private parts or body parts are recorded without their knowledge. And so this statute codifies the expectation for individuals in Montana to not violate someone's right of privacy by recording them without their knowledge, taking a video, recording photographic images of them without their knowledge. And that applies to a certain extent in a public place, but a public place, a person can still be recorded without their knowledge, so long as it's not recording them in a way that violates their right of privacy regarding their personal effects or body parts. And so we'll talk about how that all fits together with other statutes as we move through the presentation. But that statute talks to visual observation, visual recording. 45-8-213 moves into audio recording. And the statute specifically states that a person may violate the law if they cause or record or cause to be recorded any conversation by use of a hidden electronic device that produces that conversation or human voice without the knowledge of all parties in the conversation. So that would be if someone secretly records a meeting that you're in or secretly records a conversation that you're having on the phone or in person, there's an expectation that everyone knows that they're being recorded. Except, as you can see, the statute has some exceptions by stating it doesn't apply to elected or appointed public officials or public employees when the recording is done in the performance of a public duty. People who are speaking at public meetings do not have an expectation to be notified in advance before they're being recorded. There's an expectation that they could be recorded because of the recording for purposes of meeting minutes or broadcast of a public meeting. So there is not an expectation that everyone be notified prior to discussion or public comment or participation in a public meeting, or if someone is engaged in an official duty as part of their role as a public employee or a public official. Or if that individual and the individuals involved in the conversation are told in advance that they're going to record the conversation. At the point where that notification occurs, then either party may record the conversation so long as there has been that notification. So we start to see the concept of notice and notification, being aware that you're being recorded, being aware that you're in a public place, or being aware that you're in a public meeting. All of that starts to fit together for both video and audio recording and how that applies to surveillance in a public setting by a government agency. A new and emerging issue is the concept of facial recognition. And more surveillance platforms have facial recognition technology either embedded within them that can be turned off or turned on, or it may be an added service that an individual who's contracting with a third party providing surveillance could agree to utilize the facial recognition technology. The legislature has addressed this the last few sessions and developed legislation on how facial recognition technology can be utilized. And you can see this isn't in the criminal code, but it exists in the statutes governing how facial recognition can be utilized. There's a general prohibition on facial recognition that applies to local governments. This that does not obtain, retain, possess, access, request, or contract for the use of continuous facial surveillance. Facial recognition technology for facial verification, including data, may not be used to aid or assist in any type of continuous facial surveillance. So you have that understanding that technology that can scan someone's face and monitor them and have continuous access to their presence and their location based on their facial features or based on their facial profile is prohibited. The prohibition on facial recognition technology. There's some exceptions that we'll talk about in a minute, but again, local government is not going to obtain, retain, possess facial recognition technology or information derived from a search using facial recognition technology, enter into a party with a vendor for purposes of facial recognition technology, install or equip continuous facial surveillance and monitoring equipment in public buildings, public roads, or highways, except as permitted by law. So you can see the legislature developing this baseline expectation that local governments are not going to be utilizing facial surveillance, facial recognition technology as part of their general surveillance, which is permitted by the statutes we just talked about in the criminal code through notification and through responsible use of recording and imagery. That does not extend to facial surveillance, facial recognition. However, there is an exception, as noted in the law, that if there is a need for facial recognition technology to be utilized, then that it has to be done through compliance with a written policy that complies with the statute. That if a local government is going to utilize these facial recognition, facial verification, facial surveillance, then how it's going to be utilized, the purpose for which it's going to be utilized, the term of which the facial biometric data is collected and stored, that there's notification as to how that data is collected and how they may be permitted to provide or withhold written consent for that facial biometric data to be stored and collected. And then there must be an option for those services that are provided by that local government agency to be provided without that consent being provided. Any third party vendor that's going to provide the service to a local government must have written policies in place that comply with other aspects of the law before that technology can be utilized. And then there must be compliance with any regulations that are promulgated by the state as part of its information technology board that is established in Title II. So there's a baseline expectation among Montanans that they're not going to be subject to facial recognition technology by their local government or law enforcement agency. If there's a need for that local government or law enforcement agency to utilize facial recognition technology as part of its surveillance platform, then there needs to be some strict adherence to the protocols established and outlined in the statute. The difficult concept with regard to this, the implementation of this, is ensuring not just compliance with the state law, but compliance with local government expectations within your community. Anytime a library were to be considering something like this, there would need to be consultation with the county attorney, city attorney, as well as local law enforcement, and anything related to compliance with the state regulations that we've talked about. It's unlikely that this type of facial recognition technology could be utilized in a library for reasons that we'll talk about later. However, the law does address it now, and you need to be mindful of it. If a vendor does approach you and say, yes, you have this platform that you're currently using, we have these add-on services that might be utilized. Are you interested in doing so? And before you were to jump into that conversation, you now have the knowledge or the understanding that facial recognition technology has some very rigid expectations that come with it before it can be utilized. So we talked about surveillance. Surveillance is permitted in compliance with the state's criminal code. Additional services within that surveillance platform that might include facial recognition technology have some very rigid expectations. And so that is all part of the library's operations. But there are other non-surveillance recordings that can occur within the library space. The first is library staff or library volunteers that are taking footage. And one of the areas of the law that you need to be mindful of with that type of recording, where the staff are taking images on their phone, are going to be uploaded to social media sites or used on a website or used by some other part of a campaign or profile on the library, is if children are present, that there's statutes governing the rights of parents regarding the videoing or recording of their child. And the past few sessions, this area of law has developed in terms of the rights of parents and how those rights that we all know exist are now codified in a law. And the statute stating that interference with parental rights is restricted. There needs to be, again, a compelling state interest for any type of interference by a government entity in the raising of parents' raising of their child. And one aspect of this that has evolved more clearly is that the concept of the parent providing consent to a government entity before that government entity takes audio or video recording of the child, unless that audio or video recording is at an event open to the public, including a public performance, athletic competition, a preparation, dress rehearsal, practice event open to the public. And so to break that statute into pieces and give it a little more analysis, there is an expectation for governments to secure written consent of a parent before that government entity were to film or record, photograph a child. That parent would have to give that consent. That requirement for consent does not apply if the event that's going to be recorded is open to the public and is considered a public event. And so many schools, libraries have been working on this issue and handling this issue and how that recording or photograph can be taken, utilizing the exception that's now created and established within the law. The library staff or volunteers as agents of that library, of a government entity, may take that footage without the consent of a parent if that event is open to the public. It's important to have a policy or a procedure, protocols detailing when an event is considered open to the public. And so if that's library programming sponsored by the library, at the library, offsite programming that's sponsored by the library, how the event is considered to be public and open to the public is important to ensure compliance with the law, because we would not want the parent to feel that the child was recorded or photographed without the parent's consent and have confusion as to whether that event was open to the public. And so it's important to define when that is. And it might take as a next step is to provide notification to those present. This is a public event, and as a public event, there may be a recording by library staff or volunteers. And then having that staff member or that volunteer noted some insignia, their name tag, other ways to demonstrate to those present that yes, this is not just some random person that's taking pictures of children. This is a member of the library staff doing so in accordance with their roles and duties, in accordance with their job description as part of the operations of the library. That reassures parents of that this person is safe and appropriate for taking those images, but also that helps the library comply with the statute. Additionally, making sure that those images that are taken or the footage that is created is stored in a responsible manner. That the images are not somehow misplaced or otherwise misused is another way to have a reassurance to those that have their picture taken that this is going to be handled appropriately. And so making sure, again, you have the staff members clearly identified, you have the events clearly identified, you have a process and protocol in place for the safe storage of information, and then the willingness to work with parents or guardians in the event that they say, I understand it's a public event, but could you not film my child? There may be estranged family members or others that they don't want to know where the child is, or there's a variety of different safety issues that could come up. And then being willing to work with those parents to not include that child in anything that's distributed to the public or anything that is posted to a website or distributed elsewhere. That's a community relations component that's very important when working with patrons, even though it might not be specifically stated in the law. There is an additional aspect to this that if it's not, we're not quite sure, is this a public event? We're not quite sure, is this an event that's widely open to the public? Is it not? Is it not library sponsored? The additional caution, concern, respect for families by securing parental consent, verbal consent or written consent if possible. Maybe a little extra work, but it can go a long way to, again, reassuring everyone that this is something that we're doing to make sure to help preserve the safety of our library setting and the safety and security of all our patrons, including those that are children. As we know, so the Constitution says that those children have a right of privacy. The parents have a right to raise their child as they see fit. They're accessing the library. That the moving parts of a public event versus a library-sponsored event versus an event hosted at the library by a third party, all of that should be taken into account to ensure that we're just on alert about the need for safety with regard to children. And so taking that all into account is very important. The non child, the adults that are present in the library that are at events, there isn't a specific statute that's going to govern them, as you see with children, other than the fallback that we know with regard to the statutes in Title 45. If they're at a public event, at a public meeting, that could be recorded. There's an implied consent that their presence at the location, if they've been notified through a signage or other notification that the area is subject to recording and surveillance, their continued presence at the area does constitute that consent to be recorded. If someone were to approach you as a library staff member or a library volunteer and say, I'm not comfortable being on film. Is there a place I can stand where I won't be recorded? Again, trying to work with them to respect that privacy so that they're not deprived access to the library's programming and services while still being able to respect their privacy for whatever circumstances they may have in their life that doesn't include them wanting to be distributed. Trying to be mindful of that, approaching it with empathy and compassion can go a long way to helping reassure them that the library has their interests at heart. And if it's not possible, being upfront and explaining to them that we have cameras throughout because this is a special event, it's being recorded for community TV or whatever the case might be, helping them access those services in another way is important. So a blend of some legal information along with some best practices on community engagement when it comes to that non-surveillance library generated recording. Then there's the added issue of a patron engaging in recording. And this comes back to the series of of topics we've discussed the last few weeks with regard to person's First Amendment rights, the person's access to information in the library, and the fact that the library is a designated public forum. As a designated public forum, we know from our previous sessions that the patrons may engage in speech. They may engage in conduct related to that speech, so long as it's consistent and compliant with the expectations established by the government agency which has created that designated public forum. Recording the space is considered speech under the First Amendment, and it can be considered engaging in speech by actions that are designed to either access information or create information that will be accessed by others. If it's a recording that will be distributed via social media or website or other information that's being collected to generate speech. And so balancing the rights of that individual to engage in speech while the others in the designated forum are there to access information through the library services is going to come back to what we spent last week talking about, which is the patron conduct policy. And so anyone who's engaged in a recording consistent with their First Amendment rights has to do so in a way that doesn't infringe upon the First Amendment rights to access information that are held by others in the library space. And so that patron conduct policy, if we think back to the prohibited conduct that interferes with the operations of the library, conduct that infringes upon the other patrons' right to access information, conduct that is disruptive, conduct that violates state laws such as a disorderly conduct statute or violation of a disruption of a public meeting, interference with the ability of a public official to complete their duties. All of those different factors could be triggered or could be touched upon if someone is engaging in disruptive recording of the library space as a public area, as a designated public forum. If we come back to the concepts of a safe and welcoming environment for library patrons to access information, and someone is approaching them with a camera, makes them uncomfortable, forces them to leave the library. If you equate it to someone acting disruptively, speaking loudly, approaching someone who doesn't want to be approached and trying to speak with them or yell at them or engaging in that type of conduct and knowingly engaging in that conduct, as we talked about last week, then that can be considered a violation of the patron conduct policy. And so it's that balance that is required when not only drafting the patron conduct policy, but then enforcing it. And you can go back to last week's session to get more information on how that would fit together. But with the understanding that someone does have a right to record, so long as that recording does not interfere with the ability of the library staff to manage the library and operate it efficiently in accordance with the mission of the library and in accordance with the laws of the state of Montana and the United States, while balancing against the rights of others to access information in the library. That's how the concepts of patron recording have to be taken into account. That same concept of safety for children can be taken into account here as well. A person who is lingering in a library setting, perhaps filming children without parental consent, that's not a government agent that's engaged in any type of recording. So that's the statute that we talked about in Title 40 wouldn't necessarily apply. The patron conduct policy would have to apply. And if the patron were to approach library staff and say, this person is recording me, recording my child, I don't know them, I don't know what they're doing, then that can elevate the situation to not just a patron conduct violation, but perhaps disorderly conduct beyond that may require some prompt intervention, again, to preserve the safety of the setting. And so balancing all of those rights is something that staff are required to do in real time, and having a sound policy is necessary to ensure that those rights are balanced appropriately. So all of this comes back to a library. How do how do we manage this in a library? And we're going to be guided by the Library Confidentiality Act. In Title 22, we have that specifically noted that what a library is and what a library record is. And a library record is anything that identifies a person as having requested, used, or borrowed library material, other records identifying the names of personal identifiers of library users. You think to a surveillance camera near the checkout desk that shows what that person has checked out. You think about recording, audio or audio recording, talking about what book they're requesting or talking about with a librarian. Facial recognition technology that identifies that person, says who they are, as well as accompanied by a demonstration of what book they're checking out. All of that has to be taken into account with the placement of cameras, recording devices, and any other surveillance technology in that in and near the circulation desk or checkout stands. And that needs to be embedded in your policy. It needs to be noted in the board's development of its official practices with regard to surveillance and recording. And by extension, I think it has to be part of the patron conduct policy. If a patron is sitting at the entrance or near the entrance of the library and they're trying to record what everyone checks out, is there a breach of a person's confidentiality? Does the library have an obligation to redirect that patron who's engaged in that recording to preserve the confidentiality of the others who are present in the library and attempting to access information? I think that could be something that the library would have to redirect because it's not falling within the exceptions of a court order or trying to collect fines or recover lost materials, or the person hasn't given written consent. And so you get into that type of situation where people are trying to record what others are checking out. That might be a cause to take, again, prompt action to determine what exactly is happening, enforce the patron confidentiality law, and comply with the Library Confidentiality Act to, again, preserve the rights of the patrons that are in the library while balancing the right of others to engage in speech in a designated public forum. So we know the placement of surveillance, we know the recording by library staff for non-surveillance purposes, and the potential recording by a library patron all needs to comply with the library confidentiality laws. And then the last statute to talk about is public records laws. There's a provision in the public records laws that everyone should know about, and that's in subsection 2 here. We know that everyone has a right to examine public documents. That's embedded in the Constitution. It's our inherent right as Montanans. We have a right to know what the government is doing, how they're spending our money, how they're operating, and how they're serving us as citizens and as taxpayers. But there's a general, generally understood restriction on that public information would not pose a security risk to the community. And so the public officer may withhold from public scrutiny information relating to public safety or the security of public facilities, including public buildings, if that information jeopardizes the safety of the personnel, the public, or the people in the facility. And that comes back to details related to the surveillance system, details related to a security system, details that might have be part of an emergency response plan. That type of information could be misused in order to harm the public, harm the people present in a public facility. And so having that understanding that someone were to request, can you give me the layout of your surveillance system? Can you tell me where all the cameras are? Can you tell me where all of the meetup places for an evacuation are? That type of information can be withheld from a public records request to the extent that it's designed to preserve public safety and facility security. A public contract about those platforms or that technology would not be protected from public scrutiny because it's a public document about the expenditure of public funds. Instead, it's the details associated with issues to preserve public safety that could be withheld. Anytime that type of request comes in, you're going to want to consult with counsel. You're going to want to review the request very carefully to ensure that the information that is provided is truly of a public nature. As librarians and information professionals, we're not in the business of hiding public information. We want that to be disclosed and people to know that their government is operating in a transparent and accountable manner. But we also want to make sure that we're not putting the public at risk. And so this statute is designed to achieve just that. So, but you have to be carefully scrutinize and analyze every request and every piece of information to ensure that nothing is improperly disclosed or improperly withheld. This issue can also come back to the actual footage itself and how the footage can be maintained, retained, and distributed if requested. Is public surveillance footage a public record? Or is it designed for safety and security purposes? Is it maintained for an extended period of time? Is it retained for a period of time? All of that needs to be outlined in the policy and needs to be handled on a case-by-case basis, consistent with each of these statutes that we've discussed. So that's a lot of law in a lot of different parts that you have to be mindful of. It might be a stopping point for many questions about how these all fit together when we start talking about a library policy on these topics in our next section. Any questions that have come in?
No questions yet, and I might reserve the one that I have actually for a little bit later. But there are no questions in the chat.
So we have all of these statutes, all of these concepts. How do we put them all together into a policy for library operations? And so we know we have four different aspects of this issue that we have to make sure that we're addressing. With the public surveillance, we have the rights of individuals to engage in speech in a designated forum, the obligations of library staff to responsibly film children, and how that all fits as public records. And so when looking at a library surveillance and recording policy, you might have one policy that captures all of those different parts. You may have it related to some components on patron conduct, some components on library surveillance, some components on non-library surveillance recording, and then public records. So you may end up with four different policies that all cross-reference each other. And regardless of how it's put together, there's some things that you have to remember as you start working on that policy. Surveillance and recording provisions are going to be there to support the safety policies and protocols of the library, to ensure that the library remains a safe and viable place for each employee, each patron, while ensuring that people that are present in the library access information, that their rights of confidentiality and privacy are upheld in that safe and welcoming facility. There's going to be cross-references to the public records laws, a patron conduct policy, and then there's going to be coordination between all of those documents. And that coordination is going to ensure that people who are present in the building know that the library has their rights in mind, their rights of privacy, their rights to access information, and their right to a safe and welcoming security, and how the library is balancing those three rights to ensure that the safety and security poses minimal interruption to their right to access information, while ensuring that it does not breach their right of privacy. That all has to fit together. It also has to take into account any coordination with first responders through the emergency response and preparedness plan that the library has established, to ensure that if there is any type of incident, that the library continues to operate efficiently and safely, and that the first responders are able to have information they need to promptly intervene and restore that efficient operation when and handle the incident consistent with the law and the practices established by the library. There needs to be an established process for how library staff and volunteers engage in library non-surveillance recording and the expectations for patrons when they are attempting to record something or take pictures in a designated public forum as the library is. All of this comes back to the goal that we've talked about the last several weeks, which is a policy that's understandable, accessible, enforceable, and supports the library's staff in making decisions to meet the library's mission. And so we talked last week about the fake library, the Mosaic Public Library, and how its mission is to serve each member of the community in a welcoming and secure setting as they pursue lifelong learning goals. That captures the three components we've talked about, which is the purpose of the library to give access to information, provide access to information in pursuit of that person's lifelong learning goals, that the library is there to serve each member of the community, and that the library seeks to establish a welcoming and secure setting. So we know that that mission is there, and it's going to be, again, at the top of each of the three or four policies that we might be working on to address surveillance, recording, and confidentiality in the library session. How that's going to work is first outlining how surveillance is justified for use in a library setting, how and why the library needs that surveillance to achieve its mission. Then a reference to how the staff or the director or designated staff is authorized to make decisions about surveillance in order to achieve that mission. In addition, there has to be a process detailed in the policy about what the surveillance is taken, what footage is preserved, what footage is maintained, how it's retained, and who has access to the system. And by extension, who can request copies of that footage, how it is handled when there is a request for footage, and how that's coordinated with first responders in the event of an emergency. The policy should also provide that detail about library staff who are engaged in non-surveillance recording, and that they will be identified by their name tag, that there will be posting at the event that this is a public event subject to recording, and how that notice differs from the recording or surveillance notice that is placed at the front entrance of the library or in areas where cameras exist. And then the final aspect, ensuring that there is components of the patron conduct policy that ensure the library can redirect recording by a patron that is disruptive or in some way improper. So we have those fundamentals that we know have to be in the policy, how these all fit together through the components within the policy, and some examples as to how that can come together into some specific provisions. So you have some statements here, similar to what we worked on with the patron conduct policy last time. Library shall utilize technology to honor the library's mission, to provide a safe and welcoming setting, and to protect the library's property, facilities, and equipment. That surveillance technology shall comply with the Library Patron Confidentiality Act and applicable laws, regulations, policies related to record maintenance, patron and employee privacy, and library operation. So you come back to, we know we have to comply with Library Patron Confidentiality Act. We also know that these can be considered public records, and so we have to maintain those records consistent with the local government records retention schedule, as promulgated by the Secretary of State's office. How that patron and employee privacy is preserved, not just through what they're checking out from the library, but the placement of the cameras are not going to include areas where anyone might be in a state of undress, or any areas where there might be capturing footage of a personal or intimate nature, that the facial recognition technology is not going to capture them without the appropriate authorization in accordance with those laws, and that the all comes back to any preservation of order consistent with a uh, emergency response and preparedness plan. The policy could authorize the director to identify the appropriate locations for surveillance cameras in the management of the system. Camera locations will not again violate anyone's privacy. The responsibilities governing access to the system and management of the system will be outlined in the respective employee's job description. Detailing that, cross-referencing the policy with the job description to ensure that the two documents are talking to one another. And then posting notice at the entrances, as we saw in the laws regarding visual recording and audio recording. There's an expectation that people know when they're being recorded in a public place. So you place that notice at the entrance of the library, as well as any distinct area where there's a presence, a camera's presence that will be a part of the surveillance system. And having that notice there that there is cameras present and the person is subject to surveillance by accessing that area of the building or those services in those areas. Then one that will have to be customized based on the library's operations. Is that just video, or is there audio components to the surveillance? If so, then that's an added aspect of the notification, and it has to be detailed in a way that people know that this isn't just video surveillance. This is including audio surveillance, and again, the added legal expectations for confidentiality and privacy that come with audio surveillance um, are numerous and something to be taken into account when developing that system. And so putting that together would require consultation with legal counsel to ensure full compliance. The same goes for those facial recognition technology issues that we've mentioned. The legislature's attention to that issue, I think, is consistent with the Constitution's statements and preservation of the rights of individuals in Montana to have a right of privacy, and utilization of facial recognition technology creates several added requirements for a policy to comply with the law, but also comply with the rights of privacy of individuals under the Constitution and the library patron confidentiality laws. A statement in the policy that video recordings may be preserved and utilized as part of investigations into misconduct, consistent with the policy on patron conduct or a collective bargaining agreement or a personnel handbook, employee handbook, and the like. And then a statement cross-referencing anything regarding a public record. It's not generally considered a public record because of the safety and security component. However, if there is a request for footage, then it's important that that be handled in accordance with the appropriate law and policy or emergency response protocol. This type of statement authorizes the director to make the necessary inquiries about the circumstances. Is this a public record? Is this a matter of personal privacy? Is this an issue related to an investigation that would create a right of privacy? Is this a request where the person is attempting to utilize the public surveillance for personal goals, personal needs? Is this an emergency that requires prompt reaction in coordination with first responders in order to help save life and property and preserve order? All of those can be taken into account by the director, consistent with their role as the person who's in charge of the library and person who's in charge of managing the surveillance system. So that type of authorization is important. The policy could get into additional detail if necessary, but it's a general statement like that can be the start of the discussion and the start of the framework for how requests for footage are handled if they were to come in. And then some additional aspects of the issue that we talked about: patron conduct. we talked in detail about a patron conduct policy. If there were to be additional language that the library wanted to review or consider, having that patrons statement that patrons who are not affiliated with the library who are engaging in recording in public areas of the library shall comply with laws. There's the presumption that they can do it in that statement, but they have to do so responsibly. Recordings that violate district or disrupt library operations or interfere with the rights of others to access information are not permitted. Library staff are authorized to take action. If there's a recording that's occurring for commercial purposes, the use of public property for personal enterprise or personal profit should occur with the authorization of the director, and that type of use of public property should be handled in accordance with the law. Then those same concepts that we talked about in terms of library events, that the library staff and volunteers authorized to broadcast, take video, audio, photographic recordings, they can do so so long as they have identified themselves and that there's notification to those that are present, that they'll coordinate and collaborate with families. And if there's an event that's not considered to be public, or there's concern that it's not specifically public and open to everyone, then there would be a need for the library staff to secure that consent before completing the recording or utilizing the footage. And if the news media is going to be present, they have that ability to be present, to broadcast and stream and take footage, but they should do so with the knowledge of staff, and that the library staff knows that the news media is present and that they're doing so consistent with journalistic protocols. A part of this issue is library board meetings, and there's another statute that allows for any person to broadcast or stream a public meeting, and it can't be interfered with by the library or the government agency. A person can stand there and record a meeting, stream a meeting, broadcast it on their personal site using their personal devices, and that's something that cannot be interfered with. That same concept exists within the audio recording of a meeting. A public meeting is not an area where there is a right of privacy. So those concepts should also be utilized and relied upon with regard to public meetings and board meetings in particular, that individuals have the right to record or stream or take the audio recording in order to distribute and provide information about the operations of their government. So another aspect of that to keep in mind, a lot of different issues to take into account. You can reach us at any time at the helpline at mtlib.org, and we'll be ready to assist however we can on any of these topics or others that you've encountered in your library. So I'll stop sharing. Are there any questions that anyone has as we reach the hour mark on this topic?
Yeah, there is a question from Tracy. And her question is about the devices that you would use to record. So she says, I suspect very few libraries have dedicated cell phones to record public events. So private cell phones are most likely recording public library events. That seems like a very gray area to me, especially when it comes to proper storage of recordings. What is your vision for that?
It is important, and it's an issue that comes up frequently for public employees, that their personal device is oftentimes by extension their employer's device, and they're using it for email, using it for phone calls, they're using it for recording. If the library staff are collectively bargained, that may be addressed within the collective bargaining agreement, and how the individuals may use those devices or a stipend that they may receive in exchange for that use, or how that use will be recognized, rewarded. If it's not detailed in a collective bargaining agreement, or if the library staff are not collectively bargained, library establishing protocols for use of those devices are necessary. As I mentioned, and as you referred back to, there needs to be safe storage of those images, and that's in the library's interest. that there isn't some image that falls into the wrong hands because of the library's negligence. And so if there's not provision about employee use of their personal device for public purposes, or if there isn't a device that's available, then it's important for the library to include in its policy, its employee handbooks, that if you are utilizing a personal device for public purposes, any images or recording that are captured using your personal device are immediately uploaded to the library's publicly held server and not maintained on your personal device. The important part of that then is that occurs. The worst thing that could happen is that it's recorded on someone's personal phone. It doesn't get uploaded. That phone is lost or stolen, and then those images or that recording falls into the wrong hands, misused. The library had a policy that it didn't follow, and it resulted in the exposure of images that were not um, for the misuse of those images by someone who's not a library employee. You have multiple violations of policy. You have perhaps a violation of parental rights. And so developing those protocols, given um, the structure, the format, the budget of the library are important. And if there is an expectation for employees that might use their own device, um, that the images that are captured are immediately stored on the library's publicly owned servers. That's the advice. That's the process, and it can be tailored and customized in order to meet the specific structural and budgetary needs of that library.
I think, Kristen, maybe you can clarify this too. Back in the olden days when we didn't all have a video recording device in our pockets, typically in the libraries that I've worked in, there would be a dedicated device, whether it was a video camera or, even just a camera that had video and still picture capability. And that eliminated then exposure potentially if there was a public records request or a subpoena to request footage, then, it's on the publicly owned device. It's not on a personal device that would then have to be turned over in that type of request.
Right.
It seems like an easy solution. The library needs to provide the equipment, and as strong as the urge is for us to just whip out our phone and do the thing, it might not be in the best interest of anyone to actually rely on that for creating recordings.
It's a great point. And if it's a matter of convenience that, well, I have my phone, I forgot the camera, that's it's not an excuse. And it's same with email. You think about email, I'm going to just take this quick uh, email through my personal email address, and that then creates a presumption that your personal email address is used for public purposes, which could create a whole review of your personal emails. And so keeping that distinction in place is important. Having protocols in place to avoid that exposure is important. And if possible, having a dedicated device at the library for use of and recording of public events is important. Or if there is a member of staff whose device is paid for by the library, the director gets a phone as part of their job, then that could be the designated device to conduct and complete those recordings. However it's done, making sure you're promptly uploading those and storing them safely, consistent with records retention laws and the personal privacy rights of anyone who is present is important.
Yeah, and kind of along those lines, I know that we're running up against the top of the hour, but Carrie's asking about would a blink camera that records audio and video during open hours be permissible if you had a policy regarding it and it didn't cover the computer desk? So I'm assuming, that a camera wouldn't be positioned so that you could see somebody's viewing and browsing history,
Correct.
that sort of thing.
Yeah, and that's the same concept as the the camera near the the checkout or circulation desk or checkout kiosk is not having that camera near the patrons who are utilizing the public computer terminals. And if you have a, a camera or device that is there for staff use, that it's being utilized in accordance with all of those patron confidentiality laws.
No, that makes sense. And I had a question about parking lots, but I think we're gonna have to put that in a parking lot for a future webinar that we do. And it does, what we were just talking about too, kind of cues us up nicely for our next session next week on meeting rooms and the library's public forum. There's so many connections, as you've demonstrated, in thinking about the connection between the Constitution, law, policy, and being able to clearly demonstrate how those things are not in conflict with each other. So we're going to dive more into all of these things in the coming weeks. And I really appreciate everyone's time today. The recording will be, for this session, will be available later in the Aspen event, along with the slides that Kris is providing for us. And we just appreciate everybody's time today. Thanks, Kris.
Thank you, everyone. See you next week.